Hello and welcome to the Three Questions Podcast, where we dive deep into the world of wealth management and connect you with industry experts. I'm your host, Wayne Baxter, Senior Executive Manager at One Capital Management. Now, our viewer, someone close to you, is a high net worth Canadian reviewing or updating your estate plan and wondering whether everything is truly in order for your loved ones. Stay tuned. Our topic this week, the three questions high net worth Canadians should ask when reviewing their estate plan. Thank you for taking time to check us out. And if you enjoy this episode of the Three Questions Podcast, consider liking this video and subscribing to our podcast and YouTube channels. For high net worth Canadians, having an estate plan in place is only the first step. Over time, life changes, family dynamics evolve, tax rules shift, and assets grow in complexity, which means even a well-crafted plan can quickly become outdated or leave gaps that create unnecessary taxes, disputes, or stress for loved ones. Now, that's why regularly reviewing your estate plan is one of the most important things you can do to protect your wealth and ensure your wishes are carried out exactly as intended. And that's why we're covering the three questions high net worth Canadians should ask when reviewing their estate plan. Joining me on the Three Questions Podcast from Toronto, Ontario, my former home, is Ed Olkowich, a certified specialist in estates and trust law. He's also known affectionately as Mr. Wills. He has decades of experience helping high net worth individuals and family protect their assets and provide their loved ones. Ed is a trusted voice on wills, trust, and power of attorneys and tax-efficient estate strategies. And I got to say, this is rather long overdue, Ed. It's great to see you again. Been a long time. For those who don't know this, but back in the day when I had a radio show on AM 740 in Toronto, Ed was a regular contributor to the radio show and tolerated my questions and would make the way from his home in Etobicoke, Ontario, down to downtown Toronto to not just do it over the. He could have called in, but I used to get him to come down to the studio, and he used to come in and do the show with me, and it was always great. I think I enjoyed the conversations after the radio show as much as I did the ones on. So great to see you, Ed. Looking great.
Thank you. Same here.
And appreciate having you on the podcast. And before we get into the questions, I want to sort of set some context here from your perspective as the attorney who's meeting with clients. What are some of the more common reasons you have clients coming to you for why they want to review their estate plan? What are you seeing at your end as the motivation from the client perspective that they want to get their estate plans reviewed?
Everywhere I go and people find out I'm involved in the estate and trust world, they ask me what they should be doing. And I'd say, well, do you have wills or powers of attorney or trust documents and family mortgages or corporations? And they say, yes. And I said, well, are they covered by your will? Yes, they tell me. And I said, well, where is your original document? Because if you don't have an original, you don't have a will. And people tell me, well, our lawyer's holding on to it. And I said, well, that's no good. Do you know how your executor or a person who has your need for a power of attorney can get access to the document? And they say, our lawyer has everything. And I said, well, you better check with your lawyer before you go away on a vacation for several months to find out if they have the original documents. They call the lawyer and they find out he's retired or he's merged with another law firm, and no one can find out where the original documents were. I had a client go into the hospital and somebody called me on a Saturday night and said, I'm looking for a client's power of attorney that you did in 1998. And I say, well, I can't talk to you. I don't know who you are. You're calling me from some hospital and you're asking if my client's got a power of attorney. I'm not allowed to tell you that. I can't tell you who my clients are. Why don't you ask them? And they say, well, they're in shock because they're in the hospital. I said, so am I. They're in the hospital. You got to talk to them. They may have gone to another lawyer. They may have updated their powers of attorney 10 times since they saw me in 1998. I can't speak to you. They have to call me and authorize me to release that kind of information. So if you don't have the original documents, you're out of luck. I can't review them. I can't tell them whether or not they should wind up their corporation to avoid double taxation. I can't tell them if they need to have a will in another jurisdiction because they own real estate someplace else. And I can't give them any tax advice So I tell them I have to go to an investment advisor or an accountant to get tax advice. I can only give them legal advice. So a lot of people will say, well, I did my will online. Isn't that good enough? And I said, well, online authorities who prepare wills only give guidance. They don't give legal advice. They're not authorized to give legal advice. If something goes wrong, try to call them and tell them you want them to come to court to testify on your behalf. Good
Yeah, good
luck.
luck.
Yeah, they may be like the local cannabis shop in Toronto. They open and close overnight. I'm not saying anything bad about online will agencies, but they're licensed only to give guidance. And if they've done a will that's suitable in your province, that's fine. But they're not going to give you any information for another province. And one of the things that I find that if they have real estate outside of Ontario, they may need a will in another province to be able to manage that property because usually the laws of another jurisdiction where real estate is located dictates what happens to that real estate. And if it's subject to a mortgage or a mortgage that was given to family members, you may have trouble even canceling a mortgage without a probated will in that jurisdiction. So that's something that you have to take into consideration.
So you managed to cover a broad range of issues already here, and I knew you would. Um,
Well, there are so
I
many.
well, I know, Ed, and you and I could go on for like we could turn this into a 3 hour podcast. Don't worry, we're not, but I'm just saying, in theory, we could.
Well,
Uh, so
I
what
just
I
touch
got to
on
ask
things
this,
that I can't give advice on.
I get it. So what
That's
tends to
strategy.
surprise, yeah, Ed? What tends to surprise people the most when
Well,
they
they may
finally
say, I
sit
got a,
down, when they finally sit down with you to review an existing estate plan that they haven't looked at in several years? What is usually the jaw dropping on the table moment?
well, they say, well, when I did my wills, I had 700,000 in my RSP. Now I've got 1,500,000. Why do I have to worry? I've got 1,500,000 in my RSP. And I'd say, well, you don't own it. Your beneficiaries don't own it. You share it with the government. You have to pay some tax on it. So 1,500,000, what's the net if the government takes 52%? A
It's gonna
minimum.
be, yeah, it's gonna be, you're gonna have less than $750,000. I can't remember how many conversations I had on that exact topic. Surprised you brought
Right.
that one
So,
up.
and I have to tell people that if they did their wills before 2015, the province of Ontario introduced the provincial estate tax, and they take 1.5% of everything you have worldwide. And when I tell them that they have a $3 million company that they want to sell, I say, well, a $3 million company maybe $45,000 in probate tax that they have to pay, have their executors pay. Well, how do the executors know where to get $45,000? Well, they tell me we just paid 30,000 for the funeral. We cleaned out the bank accounts. There's no place where we can get 45,000 and we want to sell the corporation. Well, is there a separate will for the corporation to avoid the probate tax? And has that been considered? No, because they did the will before anyone contemplated provincial taxes in Ontario because they were only introduced in 2015.
Well, I can just see right now that there's probably going to be episode number 2 with Ed Okovich coming up here because you've opened up a whole bunch of can of worms. So
Sorry,
no, it's all good,
I was
man.
only going to talk about solutions.
Yeah, yeah. Well, you're the agent of chaos here once again, Ed. It's perfect. So we're discussing today the 3 questions high net worth Canadians should ask when reviewing their estate plan. So Ed, let's get right to the questions. Let's get right into the meat and potatoes here. So I'm
Okay.
going to get to question number 1. Here we go. Question 1. I have my estate planning documents in place, my will, power of attorneys, and everything else, but I'm not sure everyone in my family knows exactly where the original copies are or how to access them quickly when they're needed. Is this something I should delegate to my estate planning attorney, my executor, or power of attorney? Ed, the floor is
Well,
yours.
I think there's no general rule that works for everybody because uh, if you leave everything with your lawyer, how is the lawyer going to be authorized to release things? You have to have a separate agreement to authorize the release of documents. And if somebody calls Saturday night and says, relatives in the hospital and they want to know if you have the power of attorney that you can give it to me because the doctor asked who has it. Well, I'm not going to look for things Saturday night. My office is closed. I think you need to tell the executors where the will is and where the original is, and you have to tell the attorneys for property where the originals are, and they may need them. And the person who called Saturday night to look for a power of attorney for property because the hospital want to know who can authorize medical procedures if the person who gave the power of attorney couldn't do it. Well, I said, well, where is the power of attorney? They said it's in a safe. Well, good. If it's in a safe, then you can get into it. No, they can't because they don't have the combination. So where do you keep these things? Do you keep it so nobody can find it? Like it's important that you share this information. It used to be that people thought, well, I make a will, it's all my business. I can do whatever I want. I don't have to share that information with people. Well, I think in this day and age of transparency, if you don't share information, it's like you don't really care. So you have to share the information. You have to trust people. And if you don't trust people, why did you make them your attorney? Why did you make them your executor? And if you say my spouse knows where everything is, what happens if she goes into the hospital after the car accident? What happens? Well, she can't remember. She can't give anybody advice. So you have to have a backup plan, and you've got to be able to tell people you have digital assets because you're an online poker player and you've got $400,000 in poker chips on an online resource that somebody has to be able to redeem. I don't play poker. It's bad enough that I follow the Jays.
Yeah, or the Maple Leafs.
Yeah, yeah, the Maple Leafs too.
Oh my God. Okay, so Ed, I will say this. One of the things I did back in Canada, and I still have the document in my file of documents, is I used to give every client, best as in Canada, something called an estate directory that basically was a list of all the account information and who were the powers of attorney, the beneficiaries, where the bank accounts were, the account numbers. It was one document that my clients would have and fill out. And I still hand that out today. Still give it to my clients that don't have anything like that already in place. I will give it to them to complete and to share with their attorney, their powers of attorney, and myself so that some people know where everything is. And I think that's a good strategy to employ. And in fact, I'll put it out there now. If you're listening to this podcast and you want a copy of this estate directory, just email me at wbaxter1capital.com and I'll send a copy off to you. It's a generic document that you can complete and keep and share with whoever you want to share it with. But I think that would be a good place to start, is to have some kind of a sort of a master directory that says, where everything is, so that, because like you said, a lot of times people don't know where the documents are.
No, no,
This is
exactly. That's a very good start.
as a follow-up to that, for families that have properties in multiple provinces, you alluded to it earlier, but I want to dig into on this one. So families with properties and say, live in Ontario, but they have a property in British Columbia, maybe down in Nova Scotia, my home province when I was a kid. How important is it to have jurisdiction-specific originals or copies of those documents? So you have a house, your main residence in, say, Toronto, but you got the cottage in Prince Edward Island, for example. So how important is it to have province specific documents?
Okay, so I'm only licensed in Ontario, and I've had an experience where somebody had three properties in British Columbia, and they couldn't sell them unless they had the Ontario will probated in British Columbia, because usually real estate is governed by the laws of the jurisdiction where the real
Um,
estate is. So you may need probate in the jurisdiction where the real estate is to be able to sell it. So if you have property in the United States and
I
you're a
was going to
Canadian,
bring that up too, by the way. Yeah.
well, because the IRS wants to know how many days you spent in the United States over the last 3 years. You've got to be able to tell them when you arrived and when you left. And if you can't, who's going to be able to get a hold of that information? You may be able to get it online, but if nobody has access to your computer, who's going to tell somebody that you were only spent less than 180 days on average and you don't have to file a U.S. tax return? Somebody's got to complete that questionnaire for the IRS.
I know I have clients down here, for example, that are residents of the United States and they own property in British Columbia and Ontario. And what we had to do in that instance is we had to get them, they had a revocable family trust in the state of their residency here in the US, but then we had to connect them with an estate planning attorney in British Columbia and another one in Ontario. And the all the estate planning documents kind of had to acknowledge each other's existence. They couldn't be all singular. They all had to be drafted
Right,
up. So
right.
I would imagine
And
would the same thing apply? Exclude the U.S. from the conversation. Just say you're a resident of Ontario with a property in whether it be British Columbia or Prince Edward Island or wherever. Whatever.
exactly.
Do you still does the do the estate planning documents in Ontario and British Columbia kind of have to acknowledge the existence of each other? Is that
Well,
required?
I tell people that I can't guarantee that powers of attorney signed in my office in Ontario will work in BC because they have different rules and laws.
Right. Right.
So in BC, for example, an attorney is not allowed to be paid for work done with respect to property. In Ontario, I tell them that the government has a rule that says that if the power of attorney document doesn't specify there is no compensation, you're entitled to 3% for taking care of somebody's property for on the average value of the estate for 3 years. Well, tell that to somebody in British Columbia and they'll say, well, that's not the law here. We're not allowed to pay people. And I said, well, that's not the law in Ontario. So you need different documents maybe to be able to sell real estate, and you probably need to talk to the real estate lawyer in each jurisdiction to confirm what the process is. And maybe you just decide to have joint ownership with your spouse or with the person who's going to inherit it. But the problem with that is that there's income tax
I was just going
consequences.
to say you cracked open another one. You cracked open another problem when you start getting other people involved as owners
Yeah,
outside of the.
exactly.
That's a
Exactly. Because
oh
there's a question
boy.
of legal and beneficial ownership.
Yeah, we're going to get to that in a second. So hold that thought.
I will. I will.
So our topic today is the three questions high net worth Canadians should ask when reviewing their estate plan. Joining me on the Three Questions podcast from Toronto, Ontario is Ed Olkovich. He is a certified specialist in estates and trust law. And it's great to see you again, Ed. Great to have you on the podcast. Okay, let's move on to question number two. I'm a bit confused about the difference between legal ownership and beneficial ownership here in Canada. How does that distinction affect my estate plan, especially when it comes to taxes in provinces like Ontario? Ed, you're about to
All
get into
right.
that, so
So
let's take it away here.
the difference between legal and beneficial ownership? Well, legally, you may be the registered owner of a property, but the law says who gets the benefit from the property, who collects the rent, who reports the income on an investment account. That's the person who may be the real owner. And when they die, they may have to include assets that they thought were not theirs for provincial probate tax. So there's 1.5% of what's in a joint bank account. And if it's an investment portfolio with $1 million investment portfolio, 1.5% goes right away because the person whose name is on the account isn't the real owner. So what we're required
The
to do now
beneficial
is
owner is the one who's getting the benefit of the asset,
correct.
whether it be the
So,
investment account or the property.
right. So if you want to make a gift of somebody, gift to somebody, the Supreme Court of Canada said, we don't presume that you're making a gift when you put somebody's name on title to a property. We presume they're holding it for you. So if you say, well, I'm going to give this account joint, make it joint with my son, and there's $400,000 in it, and you think you made a gift to him, well, that's not sufficient just to put his name on title to the account. You need to have a deed of gift to say, I intended this to be a gift, and they have to cash the gift and accept the gift before you die. There was a recent case where somebody said, I was going to get $400,000 from my stepfather's investment portfolio, and he told the investment advisor to give me $400,000, but I never got it before he died, and they didn't specify the amount. I took the 400,000 after he died, and the Court of Appeal said, well, you have to pay it back, and you lost the court case, so you got to pay all the legal costs too, because
Wow.
there is no proof of a gift. So you say the person wrote a letter to the investment advisor and said, I'm thinking of making a gift to my executor, but the court said, well, they didn't specify it be $400,000, and you didn't get it before they died, so you can't cash it after. So you got to pay it back.
So for families that
So
have significant real estate or investment accounts, what do you see as the most common trap with beneficial ownership? Is it that in fact the not making proper documentation?
yes, there's no proof of an intention of a gift unless you get a document signed. I'm gifting this to my child. So somebody gives you a mortgage for $750,000 to buy a property. Is it a gift? Was it to be canceled on your passing, or was it to be paid back to your surviving spouse? Or nobody gets it because it was a gift. If it's a gift, it's got to be proven to be a gift. Why would you go to the trouble of registering a mortgage?
I'll tell you right now, the web we weave. Ed, I'm perfect. Let's move on to question number three. I've been thinking about making charitable donations as a part of my estate plan. Can donating to charity actually reduce my Canadian federal income tax? And are there smart ways to structure these gifts to benefit both my family and the cause that I care about? Ed, over to you.
Good question. So, if you're a high net worth person, you don't want to donate cash. You probably will want tax advice to determine whether you should be giving it through a corporation or giving shares in a corporation. Because if you donate the shares, there's no capital gains and you get a credit. And if you get a tax credit for a charitable donation, assuming it qualifies for the uh, tax credit in Canada, then that basically reduces tax in the year of death, and they can go backwards and reduce taxes that may have been due the prior 2 years. But what that does is if you make a charitable donation, you get to support the causes that you're familiar with and that you want to benefit. And if they're a community hospital or a community care organization, you're really helping everybody in your community. And if you donate shares, you'll end up saving more and leaving more money for your family to benefit because you reduced the taxes.
How
So
how
there's
how does highly appreciated securities work? So you have you bought some maybe a stock, pick the name of the company, Bell Canada for the sake of the exercise here. And the cost basis was very low when you acquired these shares, and now they've gone through the roof. Um, how does donating those highly appreciated shares work and benefit the charity and
Well,
the
rather
gifter?
than selling the stock, you donate the shares to the charity. You may want to talk to the charity so that they're knowing what's involved and they can give you some pointers. Usually, most major charities will have a foundation, and you want to make sure you're giving the money to a foundation. They have charitable advisors who can help you structure the deal and explain what kind of clauses to put into your will so you don't sell the stock, because if you sell the stock, you have
You
to
realize
report
the
the capital
capital
gain.
gain. Yeah, you don't want to do that.
So if you just transfer the stock, the question is when is the stock to be transferred if there's a will contest? Because people do contest or challenge wills, and that's a different ball game altogether.
That's an
Uh,
episode unto its own, Ed.
yes, it is. It is.
So I got
I'm
a
well
question.
versed on that.
Yeah, I imagine you are. Um, I want to go back to something you brought up earlier, and I wanted to get some just
Sure.
before we move. You mentioned that one way to make a donation is by setting up a corporation. Can you provide a little bit of clarity on how that would work and the timing of when would you set up a Canadian corporate if you knew you wanted to donate X amount of
Well,
dollars?
everybody does it differently.
Okay,
And if people
I'm
come
hearing
into
from
my office and they want to leave their entire estate to somebody because they don't have children
right.
and they want to leave everything, then we could consider doing a charitable trust. And when you pass away, the charitable trust may own your home, but when you pass away, the charitable trust, the trustees named in that trust could sell the home or donate it to the charity. You could create a foundation. You could create a charitable trust. You could buy life insurance and have life insurance.
Right. That I've
Uh,
heard of. That one I'm more
yeah,
familiar with, I'll be honest with you.
life
I've also heard
insurance,
of I've also heard of people who've donated their RSPs to charity.
correct. And that's easy to do because you don't have to amend the will to do it. So I
Right.
tell
You're
people
just
the
making the beneficiary
designation.
on the custodial documents. You just make XYZ charity your beneficiary.
Correct. So if your financial institution has a declaration form, I tell them they may only accept a designation that's on that form. So go to them and make sure that you comply with their requirements for designating a charity. And if you have three charities, you could say you want this, your RSP or your RIF to be going to these three charities, and you can just define the percentages. And if you say you've got grandchildren and you want one third to go to grandchildren or some other causes, you can do that without talking to a lawyer, and you don't incur any costs. You go into your financial institution and say, my favorite charities will be decided by my executor in my will, because I keep changing who the beneficiaries are and the charity choices. You can do that. That gives you more flexibility.
So going back to that case, remember you're talking earlier about the person that had the $750,000 RSP that grew to
Right.
1.5 million. If they were to bequeath, okay, we're going to go to as the rule in Canada is similar to the United States with an IRA on the last surviving spouse, right? So there's no taxable event until
We
the
don't have that.
right. So United States, when the last surviving spouse dies, unless there's a disabled child, the RSP is or RIF is considered to be basically cashed out and the taxes are paid. However, if you were to bequeath that at that time on the last surviving death of the last surviving spouse, you'd bequeath that 1.5 million to a charity. That whole 1.5 million, as I recall, and you can correct me here, I don't mind. As I recall, that whole 1.5 million would go to the charity. Am I correct there?
Well, you're talking about IRS. You're talking
And
about,
I no, I'm talking about a RIF or an RSP. You're in Canada. Forget about the United States. I'm just saying in
okay, so
Canada,
if it's a
the
RIF in Canada, you leave all of it to a charity. There
the
should
one
be no
point the
tax.
1.5 million, that whole 1.5
Right.
million goes to the charity, right?
Right.
Where
That's
if you
right.
bequeath it to your children on the death of the last surviving spouse,
Oh,
that's a
your estate pays the tax. Your children get the money.
yeah, but they
So,
get 50%. So there's 1.5
no, well,
million.
it depends. Technically speaking, unless there's a holdback from the financial institution, your children would get all of it, but your estate pays the tax bill.
And if there's nowhere else to go to get the money, they take it from the
Well, the
RIF.
CRA can go after the beneficiaries.
Yeah, well, we know what happens there is the 50% goes.
Once the money goes out of the account, the investment advisor will say, we've got to talk to the CRA. We're going to hold back or deduct and remit the tax because
Pretty
they don't
much
want to get into trouble.
yeah, we know what's going to happen there. Um, Ed, based on what we've talked about today, what's one simple action a high net worth Canadian could take right now to just strengthen their estate plan? If you were to give one piece of advice, how could they strengthen their estate plan?
Show me where the originals are, and then I can look at them and tell you if they're up to date. And if they were done 20 years ago, they're not, because the provincial estate tax came in 2015 that basically kills everybody because it's a provincial estate tax. We don't have a federal tax. A lot of people will say, "Well, I've checked with people and I don't have to worry about it." And I say, "Well, I'm the specialist. Talk to me and I'll tell you. Don't go to a US site and ask them to expect them to tell you about Canadian income tax."
Or AI?
Yeah, exactly. I had a
So
fellow said to me, "Ed, what does an executor charge?" And he went to a website and said it was 5%. And he was handling the estate for 3 years. So he said, I'm getting 15%. I said, who told you that? He said, it's on this website. Well, it turns out the website hadn't been updated in years. And the lawyer had been died actually, and nobody had updated the website. So I said, well, if you're going to get your information from the internet, that's the result you get.
buyer beware.
Yes.
So for listeners who are want to integrate their estate, this is something I would recommend, by the way, is integrating your estate plan with comprehensive capital forecasting and wealth management. And that's something that we specialize in here. So if they want to integrate their estate plan with a wealth management strategy, what would you say is the next best step they should take in that direction?
Well, I can't give them investment advice. I
I
can't give them tax advice.
I
I
realize that.
say go to your advisor, get that advice, and then we'll talk about whether or not it makes sense, based on what's in your documentation and your circumstances.
So Ed, I knew I knew this was going to happen. You've definitely, for those listening in today, especially friends and clients and colleagues in Canada, you've rattled some pots and pans, which was kind of my motivation here, just to be clear. So for those who are watching or on the website, we've actually put your contact information right underneath of you so people can see how to get a hold of you. But we have people listening on Apple Podcasts, on Spotify. They're driving around in their car. They can't see how to get a hold of you. So I want you to tell us what is the best way for them to contact you? How can they reach you?
Email, I'm Ed, ED at mrwills.com. That's it. No period in Mr. Just mrwills.com.
So ed
That's the
at
best way.
mrwills.com. That's the best way to reach you.
Correct.
All right. Well, listen, Ed, I really want to thank you for taking time out of your busy schedule to spend some time with us here. Ed Olkowicz is a certified specialist in estates and trust law, and he joined us from Toronto, Ontario, Canada. Ed Olkowicz, thank you very much, and I can't wait to have you back on the podcast. We'll see you soon.
Looking forward to it. Hope I didn't just identify problems, gave you some answers.
I look forward to bringing you the 3 Questions podcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our podcast and YouTube channels. And to receive notification of when our latest episode has been posted, please click on the notifications bell. Lastly, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meet with Wayne. Thank you, and we will see you soon.